Hello everyone, welcome back. This is S.C. Coleman, author. In this video, we're going to be talking about a document which has to do with syndication. So the first thing we'll look at is clarifying what exactly the idea of syndicating for war is. It's really basic. The idea is a contingency plan. It's something that you can do to resist force majeure or otherwise situations in which you are rendered incapable of doing something. So the idea is to protect some type of activity, operation, or action against damages or loss. And this is usually done through mutual agreements of aid, dividing of tasks, and the pledges of continuity, such as we see with continuity of government, memorandums of agreements, and the division of operations and priorities, and also consolidation. So some elements is a administrative agent, somebody who is selected by the syndicate to function and operate the syndicate's structure or structures. You could have, of course, more than one agent. You could have multiple agents, which are administrators. There's going to be some type of funding function or supplyability through pooled resources, such as a pooled asset management vehicle of some sort. It doesn't have to necessarily be money, but in most cases this is funded through quote-unquote monetary instruments, debt instruments usually. There are assurances given for some type of activity, logistics, trade. So if you had an example, if you had a merchant or mercantile guilds, they would make promises to each other that if one of their operations failed to deliver something, another would make that whole, and they would cover them, and vice versa. If the other mercantile guilds were unable to do something, then another one would step in and fill the gap. And mercantile guilds syndication, or the syndication of mercantile guilds, was really seen somewhat during the age of maritime republics. And they syndicated to guard against things like storms, piracy, all that type of stuff from that era. And then, of course, banking syndication is something that continues today and has always been somewhat of a problem in regard to heinous, arbitrary, destructive, monopolistic types of control. Now, if you wanted to take a syndicate and the concept of syndication and put it on an individual level, you could have a group of people, in this case, so-called natural-born individual persons, right? Because you have to add all these acronyms and adjectives to describe what you're talking about, because the word person nowadays, despite people's customary use of it to reference only one thing, means so many other things nowadays. And that's just the way it is, even though it's wrong. So the natural-born individual persons, they get together and they decide, we're going to take a portion of our stuff and we're going to put it all together into a storage unit. And then among us, we will choose an administrator to operate that storage unit in their name. And all of those resources that we put together, we will be able to use for as trade goods or to go around and sell at, say, a flea market or something. So that's just a rather simplistic, small-time example where you take this big syndicate idea that everybody has, banking syndicates, and trade syndicates, and all this other stuff, and you just shrink it down to a very small example. there's so many ways you can form a syndicate, but the general principle of a syndicate is that it's intended to guard against problems, special problems. Now, syndicating for war means that you are putting a syndicate together expecting to go into some type of conflict in which the syndicate will be necessary to make sure operations continue. So some terms that we get from this particular document that we're going to look at in a second: equity interest in a person, attributable debt, bail in action, sustainability pricing adjustment dates, public administrative authority, reclamation of natural resources, supranational body, upstream leased assets, International Chamber of Commerce, equity holder action, material adverse effect, and the QSIP Service Bureau. All of those terms have striking connotations to them and significance. So here we have the revolving credit agreement, which is actually a syndication agreement, dated as of October 31st, 2022, among Airbnb Incorporated as the borrower, the guarantors party hereto, the lenders party hereto, Morgan Stanley Senior Funding Incorporated as the administrative agent and issuing bank, Morgan Stanley Senior Funding Incorporated, BOFA, that's Bravo, Oscar, Fox, Alpha, BOFA, Securities Incorporated, and Goldman Sachs Lending Partners, LLC, as joint lead arrangers and joint book runners. Morgan Stanley Senior Funding Incorporated, Bank of America N.A., Goldman Sachs Lending Partners, LLC, Barclays Bank PLC, Citibank N.A., JP Morgan Chase Bank N.A., and Mizuho Bank Ltd. as syndication agents. Bank of the West, HSBC Bank USA N.A., Royal Bank of Canada, Santander Bank N.A., and Standard Chartered Bank as documentation agents. So first things that we need to understand here. The funding mechanism included in this is multifaceted. There's multiple elements to it. The primary one are fees. There's an administrative fee, a commitment fee, a participation fee, and a fronting fee. Fronting fee, I think, is most interesting because Airbnb, effectively speaking, is a front organization, thus they pay a fronting fee for this banking syndicate and these various banks. So basically, Airbnb, to use the word from a attorney from Rome, is a creature of these banking syndicates, which funnels money continuously to pay off a debt instrument, which will involve money laundering. It creates the entity of Airbnb as, effectively speaking, a marionette or a puppet for financial money laundering purposes. Now, the credit history structure, as we know, is designed for money laundering through fictitious persons. But this document has a much more practical element to it. It's not simply the phony credit history system, but the fact that the phony credit history system is designed to facilitate this exact type of activity. It's not for us individuals. They create a labyrinth, and then they give themselves the rule book or the guidebook to conduct themselves through that labyrinth where the rest of us get lost. That labyrinth, one of the elements is the credit history, but it's also the fact that their institutions, they acquire and control all of the companies, all acting as fronts for their syndicated structure, right? So the syndication is behind this stuff. Now, what's interesting is they have a section here. I'm not actually going to go over it because it's not tangibly important to what, or tangential to what I'm trying to represent here, but I think it warrants mentioning erroneous payments. Erroneous payments are payments made in error. In here, they have a function to acquire erroneous payments, put them into a separate account which the administrative agent will operate, which is the weirdest thing I've ever seen. You know, how is it that you have a payment made in error that then continues to be a payment? It's not reimbursed or refunded or anything. It's put into an escrow account, which is then used by the administrative agent for operational purposes. Isn't that strange? Anyway, some terms here. Put into administration is what happens allegedly when an entity goes insolvent and they change the administrator or effectively change the control of it. They say it's to salvage it and all the other nonsense, but that's not really true. So another thing that you find in this is a complete contempt for natural born persons. There's a lot of contempt. Natural born persons are, in this context, considered to be ineligible entities, but that does not mean excluded. On their excluded entities list, they have nonprofits and subsidiaries of nonprofits. So that means that they exclude certain entities from the consequences and the planning that they're doing in this document, but natural born persons are not excluded. They're just not allowed to be involved. So that's kind of strange. The particular distaste that you find here for natural born humanity and individuals, as far as individual natural born persons go, right? So one of the components they're doing is they're planning on placing liens on future revenue, right? So this is something you saw with the city of Logan in Ohio. They promised the future revenue of public works to take out a loan, and of course they were wrong about their future revenue, and so on and so forth. But this is the placing liens against future revenue, which is kind of weird. Sort of the other side of the coin on that. There's also multiple ways to accrue interest in this document. So when you go through it, you have to understand that they have all of these little base, minimum and maximum payments and all that stuff. And on those, there's accrual of interest, such as the commitment fee is interest bearing, and so is the fronting fee. There's a lot of other fees in here too. So the idea here is that they plan to lose some of the banking institutions or some of the pieces along the way, but they'll be able to keep going because everybody else has agreed to work together in the syndication, and they can replace all of those components that they might lose along the way. So to start with, we're going to go to page 10. So just bear with me for a moment. And on page 10, we have the particular line that explains being put into administration. Person charged with the reorganization or liquidation of its business appointed for it, or in the good faith determination of the administrative agent. Well, to me, the administrative agent sounds like the entity being put into administration, because the administrative agent is, in fact, the trustee. Kind of interesting there. The next page we're going to go to is page 33. So, one moment here. Here we are. So here we're going to discuss liens. This is under the definitions. A lien means, with respect to any asset, any mortgage, deed of trust, lien, pledge, hypothecation. Now that's a term to identify. Hypothecation is fraud. Charge, security, interest, or other encumbrance on, in, or of such asset, and B, the interest of a vendor or a lessor under any conditional sale agreement or title retention agreement or any financing lease having substantially the same economic effect as any of the foregoing relating to such asset, provided that in no event an operating lease or occupancy agreement be deemed to constitute a lien. Of course, they will constitute a lien. Material adverse effects means a material adverse effect on A, the business, asset, liabilities, operations, results of operations, or financial condition of the borrower and its subsidiaries taken as a whole, or the material rights of or remedies available to the lenders and their loan documents taken as a whole. So that's a nice way of reterming force majeure and otherwise activities of warfare and loss and other things like that. They call it material adverse effect. Oh boy, these people always talk just they're always changing definitions and trying to use words that make something sound less they're always, their language patterns are so strange. Permitted liens means liens imposed by law for taxes that are not required to be paid. Liens imposed by law for taxes that are not required to be paid. Weird. And the next page, 36, is a continuation of those permitted liens. Now, I'm not going to read all of their permitted liens because it's a very long list. Judgment liens. In respect of judgments that do not constitute an event of default, easements, zoning restrictions, rights of way, and similar encumbrances on real property imposed by law, or arising in the ordinary course of business that do not secure any monetary obligations and do not materially detract from the value of the affected property or interfere with the ordinary conduct of business of the borrower of the subsidiaries, taken as a whole. So they're talking about putting liens on easements and zoning restrictions and rights of way, right? That's under permitted liens. So even though that paragraph sounds weird and doesn't sound like it applies to this, it is under the subheading permitted liens. Bankers' liens, rights of set-off or similar rights and remedies as to deposit accounts or other funds maintained with depository institutions and securities accounts and other financial assets maintained with securities intermediaries, provided that such deposit accounts for funds or securities accounts or other financial assets are not established or deposited for the purpose of providing collateral for any indebtedness and are not subject to restricting on access by the borrower or the subsidiary excess of those required by applicable banking regulations. Liens representing any interest or title of a licensor, lessor, or sublessor, including any intellectual property subject to any lease. Leasing of intellectual property. Isn't that nice? Liens in favor of customs and revenue authorities. And we'll stop there as far as permitted liens go because the list goes on and on and on. But I think those are the main points to highlight there. And the next page will be 47. And if we went through this entire document to read it, this would be a very long video. All right. So for this one, the word will shall be construed to have the same meaning and effect as the word shall. So here they just changed the definition of will, and now it means shall. That's ridiculous. Official rulings and interpretations thereunder having the force of law with which affected persons customarily comply. That's the big deal. What they care about, as they stipulated in that sentence, what they see as law is specifically and only custom, meaning what people habitually follow. And that's it. There's nothing about legitimacy. There's nothing about tradition. There's not even anything about legality. It is simply what people customarily do. And thus they attempt to change the custom. And that's what they call and believe to be fundamentally law. It doesn't have to be legitimate. It doesn't even have to be true, just as long as people do it. That is the perspective. Now the next page will be 72. Defaulting lenders. Now here we get into the revolving mechanism with which they can make sure that their operations, their hateful, spiteful, malicious operations continue. Defaulting lenders. Notwithstanding any provision of this agreement to the contrary, if any lender becomes a defaulting lender, then the following provision shall apply for so long as such lender is a defaulting lender. All or any part of the swing line exposure and LC exposure of such defaulting lenders shall be reallocated among the non-defaulting members in accordance with their respective pro rata percentages. The borrower or the administrative agent shall not be required to pay any fees to such defaulting lender. The related exposure will be 100% covered by the commitments of the non-defaulting lenders, and or cash collateral will be provided by the borrower. Any amount payable to such defaulting lender hereunder will be retained by the administrative agent in a segregated account. And now wait until we see what exactly a defaulting lender is, because it's not what you would assume it would be. Because a defaulting lender kind of doesn't make any sense, considering how most people believe default to mean non-payment. But how do you have a lender that defaults? On page 83, before we get into defaulting lenders and the definitions of it, under section 3.01, the borrower and each guarantor and each other material subsidiary is duly organized, validly existing, and has all power and authority and all material governmental approvals required for the ownership and operation of its material property. It's interesting they can just declare that. The transactions do not require any consent or approval of registration or filing with any other action by any governmental authority. Now, why can they say something like that? That's a big question. Why can they just say that, right? The borrower in each subsidiary has good title to or valid leasehold interests in or rights to use all its property material to its business. This is Airbnb. Defects in title that individually in the aggregate do not materially detract from the value of the affected property or materially interfere with the ordinary conduct of business of the borrower or any subsidiary. So there they are laying claim to the properties of everyone involved in the Airbnb business. So that means all individuals who are operating properties on the Airbnb platform are considered subsidiaries, and thus their property can, according to, which they don't care if it's fraudulent or not. In fact, they stipulate doesn't. They have a bunch of things in this to facilitate fraud. They claim it, and therefore they will acquire the properties of individuals who ignorantly, but they're not at fault here, put their properties up on the Airbnb platform. It's really mind-blowing, but there's a lot more to it than just that, and we'll see that here. So page 87 is the next one. Here, resolutions of the board of directors or shareholders as applicable of the borrower and each guarantor as applicable, approving and authorizing the execution, delivery, and performance of the loan documents certified as the effective date by such assistant secretary as being in full force and effect without modification or amendment. Well, isn't that nice? Apparently, the title of director and executive director and all these other things can just be assistant secretary nowadays. So who is the assistant secretary assisting at this point, if the assistant secretary is in fact another word for executive director or senior director, or whatever titles you want to use. Now they're all assistant secretaries. Oh, it's so strange. All right, now here's 92 is the next one. Oh, looks like I got some of my papers misaligned. So, all right. 92. The borrower and each guarantor will cause each subsidiary to keep and maintain all property material to the conduct of its business in good working order and condition, ordinary wear and tear, casualty, and condemnation accepted. So that's going to be everybody who has properties on the Airbnb platform, and possibly more than that. And here they're acting like those people are simply keeping up that property, which is actually the property of this syndicate. Isn't that amazing? By virtue of the borrower, by virtue of the fact that the borrower has, so-called borrower has taken out certain quantity of monies. It's so crazy. All right, now 94, we have no guarantor shall cease to be a guarantor solely as a result of such guarantor becoming an excluded subsidiary. Now that's strange, but not really. All right, now we're going to get into the real meat and potatoes of this document. All right. Page 99 through 102. Lien. The borrower and the guarantors will not permit any subsidiary to create, incur, assume, or permit to exist any lien on any asset now owned or hereafter acquired by it or assigned to sell income or revenues, including accounts receivable or rights in respect of any thereof, except permitted liens, which pretty much every type of lien is under permitted liens. Any lien on any asset of the borrower or any subsidiary existing on the effective date and either set forth in Schedule 6.02 or encumbers property or assets with a fair market value. It's like any lien. Liens on fixed or capital assets acquired, constructed, or approved by the borrower or any subsidiary securing indebtedness. Any lien on any asset acquired by the borrower or any subsidiary after the effective date existing at the time of the acquisition thereof or existing on any asset of any person that becomes a subsidiary. Liens solely on any cash earnest money deposits, escrow arrangements, or similar arrangements. Liens deemed to exist in connection with sale leaseback transactions, deposits made in the ordinary course of business, liens on the net cash proceeds of any acquisition indebtedness, liens on inventory equipment of the borrower and any of its subsidiaries granted in the ordinary course of business to the borrowers or subsidiaries, vendors, clients, customers, landlords, or bailees. Ground leases in respect of real estate assets on which facilities owned or leased by the borrower or any of its subsidiaries are located. Zoning, building entitlement, and other land use regulations by governmental authorities with which the normal operation of the business complies. For purposes of determining compliance with this section 6.02, if any lien or any portion thereof meets the criteria of more than one of the categories of liens described in clauses A, B through P, above and any one more of the clauses containing the definition of permitted liens, the borrower shall in its sole discretion classify such lien or such portion thereof, and may include such lien or such portion thereof, and include it in other such clauses in which it could have been included at the time it was incurred, but except as set forth with respect to clause K, not only the clause under which a blah blah blah, right? So they're reclassifying it, moving it around, adding liens, etc. It's all bogus anyway. But it is in fact, unfortunately, being done in actuality, which is a big problem. This isn't just a dead letter. It should be, but it's not. 103, the borrower and guarantors will not permit its subsidiaries to sell, transfer, lease, or otherwise dispose of, directly or through any amalgamation, merger, or consolidation, whether in one transaction or in a series of transactions, assets including equity interest in subsidiaries, representing all or substantially all of the assets of the borrower and the subsidiaries, whether now owned or hereafter required, taken as a whole. The borrower and the guarantors will not permit any subsidiary to enter into, incur, permit to exist any agreement or other arrangement with any person that prohibits, restricts, or imposes any condition upon the ability of any subsidiary to pay dividends or other distributions with respect to its equity interests or to make or repay loans or advances to the borrower or any subsidiary. And here we get into the redefinition of default. Event of default remedies. If any of the following events of default shall occur. And then we're going to look at what a default is. A warranty or statement made or deemed made in any loan document or any amendment or modification thereof or waiver thereunder shall prove to have been made or deemed made incorrect in any material respect. That's not a default. That's called fraud. The borrower or any guarantor shall fail to observe or perform any covenant, condition, or agreement contained in Section 5.02a, 5.03 with respect to the existence of the borrower or for 5.09 in any article. That's breach of contract. That's not default, but here they're terming it as default. The borrower or any guarantor shall fail to observe or perform any covenant, condition, or agreement contained in a loan document other than the specified clause A, B, or D of this section, and such failure shall continue unremedied for a period of 30 days after written notice thereof from the administrative agent or any lender to the borrower. So that's basically kind of like lack of communication means a default. Any event or condition occurs that results in any material indebtedness becoming due or being terminated. So a default is the termination of debt. What? Right? That's crazy. Oh boy. All right. An involuntary proceeding shall be commenced or an involuntary petition shall be filed. That's a default. The borrower or any material subsidiary shall voluntarily commence any proceeding or file any petition. The borrower or any material subsidiary shall become unable to pay its debts as they become due. One or more ERISA events shall have occurred that individually or in the aggregate would reasonably be expected to result in material adverse effect. ERISA is Echo Romeo India Sierra Alpha. A change in control shall occur, or any guarantee or any material provision of any loan document. Oh, ridiculous. All right, and here's at the end of all the different types of defaults, which aren't defaults, but they've reclassified or redefined the term default. Then, and in every such event at any time thereafter during the continuance of such event, the administrative agent, at the request of the required lender, shall by notice of the borrower take any and all of the following actions at the same or different times. A. Terminate the revolving commitments, and thereupon the revolving commitments shall terminate immediately. And B. Declare the loans then outstanding paid to be due and payable in whole or in part, but rateably as among the loans and or commitments at the time outstanding, in which case any principal not so declared to be due and payable may thereafter be declared to be due and payable, and thereupon the principal of the loan so declared to be due and payable, together with accrued interest thereon and all fees, other obligations of the borrower hereunder shall become due and payable immediately. Oh, what a surprise. All right, so now we're on to page 114. The administrative agent may, but shall not be obligated to make any communication by posting such communication on debt domain. Well, that's an interesting name for an online platform, don't you think? Intralinks and Syndicating. So debt domain are two words. Intralinks is one word. That's India, November, Tango, Romeo, Alpha, Lima, India, November, Kilo, Sierra. And Syndicating is all one word. That's Sierra, Yankee, November, Delta, Tango, Romeo, Alpha, Kilo. Or other similar electronic transmission system, the platform. The platform is provided as is and as available. None of the administrative agent nor any of its related parties warrants or shall be deemed to warrant the adequacy of the platform, and the administrative agent expressly disclaims liability for errors or omissions in the communication. No warranty of any kind, express, implied, or statutory, including any warranty of merchantability, fitness of particular purpose, non-infringement of third-party rights, or freedom from viruses or other code defects, is made or shall be deemed to be made by the administrative agent or any of its related parties, in connection with the communications of the platform. In no event shall the administrative agent, any of its related parties, the borrower, or any lender issuing bank have any liability to any other person, party hereto, or any other person for damages of any kind, including direct or indirect, special, incidental, or consequential damages, losses, or expenses, whether in tort, contract, or otherwise, arising out of the borrower or the administrative agent's transmission of communications through the platform. That's those are some pretty interesting things they include there, I think, anyway. And on to page 120. The assignee, if it shall not already be a lender, shall deliver to the administrative agent an administrative questionnaire in which the assignee designates one or more credit contacts to whom all syndicate level information which may contain MNPI will be made. Now those sound like secrecy markings or classification markings for the purposes of retaining control. And of course you point these things out and they would say, oh, that's all normal and all this other stuff. And in some regard they might have a well-established custom of understanding. But in actuality, they go far above and beyond in that measure for the purposes of retaining control, and even the most mundane of activities they attempt arbitrarily to keep secret. Page 122. Any lender may at any time pledge or grant a security interest in all or any portion of its rights under this agreement. Boy, that's weird. To secure obligations of such lender, including any pledge or grant to secure obligations to a Federal Reserve Bank or other central bank. I'm just imagining what they're saying there, that they can sell their rights in this agreement, which apparently has monetary value, to secure other financial mechanisms. I mean, it's all fraud. It's all bogus, right? All right. So the electronic platform designated for public side lenders has a DQ list. So the DQ list is for disqualified institutions. Now, something to note here is that they have two main registries that would be nice to find. One are the participant registries, and there's another one. I don't remember what it was right now. The administrative agent shall not be responsible or have any liability for or have any duty to ascertain, inquire into, monitor, or enforce compliance with the provisions hereof relating to disqualified institutions. So why bother classifying anyone disqualified anyway if they don't have to enforce it, right? Without limiting the generality of the foregoing, the administrative agent shall not be obligated to ascertain, monitor, or inquire as to whether the other lender or participant or prospective lender or participant is a disqualified institution or have any liability with respect to or arising out of any assignment or participation of loans or disclosure of confidential information by any other person to any disqualified institution. So I believe the idea there is that many of the disqualified institutions, they'll cherry pick and add onto a list of qualified institutions, right? And then when somebody comes here and says, hey, this is a disqualified institution, but yet they're doing stuff, then they can say, no, that's impossible because they're a disqualified institution. They can't be involved with us. And yet they are. But that's the little word game they can play. Now on page 125, it states, to the extent the administrative agent has agreed to accept any electronic signature, the administrative agent and each of the lenders shall be entitled to rely on such electronic signature purportedly given by, on, or behalf of the borrower or any other loan party without further verification thereof, and without any obligation to review the appearance or form of any such electronic signature. I think we know what that means. The administrative agent and each of the lenders may, at its option, create one or more copies of this agreement and any other loan document and/or ancillary document in the form of an imaged electronic record in any format which shall be deemed created in the ordinary course of such person's business, and destroy the original paper document. And all such electronic records shall be considered an original for all purposes and shall have the same legal effect, validity, and enforceability as a paper record. Yeah, that's nice to say, but is it true though? Now 127, this is interesting. This section is in all caps, which is different from the rest of this document. Waiver of jury trial. Each party hereto or hereby irrevocably waives to the fullest extent permitted by applicable law. They love that word. They love using it. Applicable law. Now they like to stipulate it's the law, as in there's only one, but then they use terms like applicable law. Well, okay, so which laws are not applicable? To them, I assume that would include the Constitution, the U.S. Constitution, which is in fact applicable. It's just they're enemies of that, so they won't consider it applicable. It has to be forced. The application of the Constitution has to be forced against them through force, right? They will not ever recognize it. They will also never ever recognize the nation of natural-born people, nor the land, country, as belonging to anyone else but themselves. They have to be forced to recognize it. That's the term of the use in force. Anyway, permitted by applicable law. Any right it may have to a trial by jury in any legal proceeding directly or indirectly arising out of or relating to this agreement or any other loan document, the transactions contemplated hereby or thereby, whether based on contract, tort, or any other theory. Weird word. Theory. Each party hereto, A, certifies that no representative, agent, or attorney of any other party has represented expressly or otherwise that such other party would not, in the event of litigation, seek to enforce the foregoing waiver, and B, acknowledges that it and the other parties hereto have been induced to enter into this agreement by, among other things, the mutual waivers and certifications in this section. Wow. All right, that's 127. The next document page is 129. This agreement will be syndicate level information which may contain MNPI. There's a term for you. Syndicate level information. And now on page 136, we're finally to the end. We begin the bogus signatory pages. First one is David Stevenson, acting as Airbnb the borrower. Chief Financial Officer, Hotel Tonight LLC as guarantor. A Garth Bosow, or Bosow is BOSSOW, Secretary of Airbnb Incorporated, the sole member of Hotel Tonight LLC. Airbnb Global Holdings Incorporated as guarantor with a Garth Bosow, that's Bravo Oscar Sierra Sierra Oscar Whiskey, as secretary. Next you have Airbnb Payments Holding LLC, Garth Bosow, the sole member of Airbnb Payments Holding LLC. Airbnb Payments Incorporated, Bart Rubin, General Counsel. Bart, I believe, is short for Bartholomew, usually. Morgan Stanley Senior Funding Incorporated as the administrative agent, Elitza Hansen as vice president. Then again, Morgan Stanley Senior Funding as an issuing bank and a lender, Alicia Salinger, vice president. How can you have two vice presidents? That does not sound normal. Well, none of this is normal, sure. Barclays Bank PLC, a Sean Duggan, director. Bank of America NA, Inja Song, director. Inja is spelled India, November, Juliet, Alpha, Hotel. Bank of the West, Scott Brunei. Citibank NA, Matthew Sutton. Interesting name considering there is a Sutton Bank. Vice President. Rebecca Kratz, Goldman Sachs Bank USA, authorized signatory. Goldman Sachs Lending Partners LLC, Rebecca Kratz, authorized signatory. HSB Bank USA, Elena Hernandez, that's India, Lima, Echo, November, Echo, I believe. But here you can see it for yourself. That's a name for you. To mention, I thought the HSBC Bank was Hong Kong or Switzerland or something. JP Morgan Chase Bank NA, Inderjeet Aneja, Executive Director. It's a weird name right there. Tracy Ron for Mizuho Bank Ltd. Royal Bank of Canada is a Nicholas Heslip, authorized signatory. Santander Bank NA is a Jennifer Badian, Senior Vice President. I've never heard of a Senior Vice President. That's not a thing. Standard Chartered Bank, Christopher Tracy, Director Financing Solutions. So it's the Director of Financing Solutions, whatever that is. Standard Chartered Bank. Now we have at the back of this we have these amendments and whatnot. The waiver of jury trial, right? You know, it's same old. And consolidated interest expense, so it's determined will be less than $1, then it shall be deemed $1 for purposes of the agreement. That's yet just another piece of fraud. That means if you have something that's like 50 cents, then they're just going to have it as $1, and so they have a gain of 50 cents. That sort of thing. That's not a big deal to most people, but I mean, think about the individuals who siphoned off, the decimal point, the third decimal point to transactions from banks, right? And every banking transaction they siphoned off the third decimal point, that comes up to a lot of money. And same thing here. Considering what they're talking about, being able to round up means they make significant gains just out of thin air. But of course, pretty much all of this is bogus. It's all fraudulent. It's all wicked, evil, malicious, etc. And it is understood, I think, by most that the main objective here is conquest and control of the land through the fraudulent claim of the entire country and nation being the private property of these banks through their fictitious and phony debt instruments done in bad faith and with evil purposes.